My name is Brian Funk. I've been a Delaware real estate attorney for the past 13 years. It's kind of the family business. The topic today is regarding the new 2019 income tax withholding requirements that are now mandatory for non-residents upon the sale of real estate in Delaware. The form has been required for the past 8-9 years. However, only this year in 2019 are they removing the box that says, "I don't know, I'll tell you later, and I'll file a tax return." So you might ask what the purpose of this withholding requirement is for non-residents. So income tax is imposed on the gain from the sale of real estate unless it's otherwise exempt. In English, the gain is always calculated by taking the adjusted basis and subtracting it from your amount realized, i.e. the sales price. It's harder for Delaware to collect from people that move out of state versus those in state. So now we're being required to collect the estimated payment at the time of settlement. It gets submitted to the recorder of deeds, and that form is required for your buyer to record their new deed. It's important to remember that Delaware law has nothing to do with the separate Foreign Investment Real Estate Property Tax Act of 1980. That's a federal statute and completely different from this. The start date began for the new 5403 on January 1st, 2019. Who was required to fill out the Form 5403? It's always been everyone, but the income tax withholding part is the only mandatory part for non-residents. In other words, they're only going to withhold if you're not a Delaware resident. So who is a non-resident for the purposes of 5403? Let's talk about business entities first. The first question is are you a pass-through entity? A pass-through entity is the same way you would define it for the IRS. If it's a partnership, acts like a partnership, which means a subchapter S. Is it a sole member LLC? That would be considered a pass-through entity for the purposes of this form. If it is a normal corporation, i.e. a C Corp for the purposes of this form, as long as they're registered in Delaware at the Secretary of State, they're considered a Delaware entity that doesn't require withholding. So if the entity is domesticated in California and registered at the Delaware Secretary of State as a foreign company or foreign corporation, then no mandatory withholding is required. If the entity is domesticated in California but has filed nothing at Delaware Secretary of State, then it would be considered a non-resident and no withholding would be required. So for a pass-through entity, subsection 1606A2 says that a business is considered a pass-through entity if one or more of the members are non-resident individuals or corporations. If it's a pass-through entity, then you have to do the analysis on each individual member. If just one of them is a non-resident and others are Delaware residents, then a withholding still must be done. However, the Division of Revenue has confirmed that only one 5403 form is necessary. If you need to use an extra piece of paper to distinguish between the math, how you've done it, you can do that. Individuals, determining if you're a non-resident. Under the code, you are a non-resident if you are not a resident of Delaware for the entire tax year, which is different from other tax forms. The point of the conversation here is that if you're moving out of state the day of settlement, Delaware law considers you to be, unfortunately, a non-resident, and you would need to do it a withholding from the time of settlement. That being said, it's up to the seller to make this declaration honestly. Adjusted basis is really the whole game of 5403. It's basically what you got the property for, and that's how you calculate your gain. I'm always recommending to realtors that they give this their clients at the time of listing the 5403 form so they can start determining what their basis is in the property by talking to a tax professional. Determining adjusted basis is usually an entire course in law school, which is why it's always good to have a CPA take a look at this stuff. So just a couple examples would be if the property was your primary or secondary residence for the taxpayer, that is to say it's not a rental property and it's not a commercial property, the answer essentially is the purchase price plus any cost to acquire the property, plus any improvements that the taxpayer may have made to the property. If the property was an investment or a commercial property, the answer is essentially the original purchase price plus any cost to acquire it, plus any improvements made minus any depreciation taken. If the property was a gift, not a gift received as a result of a death, then the giftee essentially takes the seller's or their giftor's basis. If you receive real estate as a result of a death, whether that's through a probate process, a trust process, it's one of the rare tax advantages you're going to get in life, where you're going to take the gifters, not their basis, but what the property was worth on the date of death. So let's say, for example, the person who gave you the property by will bought it for $100,000. That's not your basis. You take whatever it was worth on the date of death, fair market value. So that's a huge tax advantage to the recipients. So there's some other exemption boxes here available to everyone, regardless if you're moving out of state, if you're a non-resident, if you are selling your primary residence and the sales price is under $250,000 if you're single or $500 married, you could check the sale or exchange is exempt from capital gain recognition. The main hurdle here is that it has to have been the taxpayer's primary residence for the past 5 years. The IRS publication 523 goes into detail on this. There's other reasons why the sale might be exempt, such as insolvency, but those are for a CPA to determine and decide. There's another box that might be relevant here for you: gain realized excluded from income for tax year of sale or exchange. That's the third box on number 5. A good reason why that box would be relevant is if it's a 1031 exchange. Another important exemption box that regardless of whether you're a resident or non-resident, and this is basically for a lender sales, REO sales, where the lender has acquired the property as a result of a sheriff sale or a deed in lieu of foreclosure. They're entitled to check this box and there's no mandatory withholding. Another box that's there for the parties to use is when you have seller financing. We have a purchase money mortgage. The seller would be entitled to check box number 7 and not do a withholding at all. Again, this presentation is for educational purposes only. You're encouraged to talk with your CPA before filling out any tax form. I hope you've found it relevant, what we've discussed here today. Thank you.